I think we're ready for our next panel, our first after-lunch panel before our afternoon keynote. And our panel this afternoon, first panel is Non-voluntary Licensing of Pharmaceutical Patents, Assessing the Post-Doha Declaration TRIPS System. Yesterday we heard that Professor Reichman enchants years and years of Duke students with his strange spells and incantations. And in numerology, the word 31 appears again and again and again, although not all students understand why. We all know why. And Article 31 of the TRIPS system has certainly been the most politically contentious, at least on the surface, of all the elements of TRIPS. And we're all familiar with the Doha Declaration and the subsequent amendment of the TRIPS agreement and the ratification, sometimes slow, of that. But we are here to have a very interesting panel about how non-voluntary licensing of pharmaceutical patents has been happening in this new TRIPS amended environment. And our first speaker is Professor Fred Abbott, who will talk to us about law and its limitations in global public health. Thank you. Fred?
Thank you, Justin, and I'm delighted to have the very coveted right after lunch spot where the question not only is will you be awake, but will I be awake? So we're all on board and on the same page. We're here to honor Jerry Reichman, and Jerry and I, as it were, go pretty far back. I think our paths first crossed in the late 1980s. When we were both working on the TRIPS negotiations from one perspective or another. And Jerry at some point invited me to contribute a piece I was writing to the Vanderbilt Symposium on the year-round negotiations, protecting first world assets and so forth. And then Jerry and I together became quite involved in, call it, the issue of access to medicines. I recall we were together in New Delhi in early 2001 for a meeting that had been convened by Médecins Sans Frontières, which was the first time I recall a woman by the name of Pascale Boulay, who you may know, first really introduced from the MSF side the question of the so-called Article 31F problem. We started to think around how you could solve the problem of countries issuing compulsory licenses but not having the capacity to fulfill them and no available exporting countries to provide them. And we started with some pretty simple and straightforward thoughts using the international law principle of comity, which really would have required us to do nothing additional. MSF was keen on the Article 30 solution. Jerry back then was already talking about pooled procurement in New Delhi in early 2001. And although I wasn't, almost everyone at the meeting got horribly sick and spent most of the time in bed. From that meeting, we went on to the Doha Declaration, what became the Doha Declaration, negotiations, which began with efforts with the Quakers and the Dutch in mid-2001. Jerry was involved in some of the early meetings on that. And I'm going to skip and fast forward just a few, in my presentation, a few seconds, and actually a matter of a couple of years, to the so-called Paragraph 6 negotiations. Again, you may recall that while we had identified the Article 31F problem as a major issue during the Doha Declaration debate, the issue basically got punted, or let's say that's where the United States and the EU drew the line in Doha and said we're not going to solve that problem here, but instead you should go back and negotiate it further. So we spent another 2 years negotiating that. And subsequent to the article, the waiver, the August 30, 2003 waiver, which provided a solution, an interim solution, And then there were the negotiations for the amendment. Then Jerry and I were invited by the European Parliament to provide our recommendation about whether the EU should ratify and adopt the what became the Article 31B solution. And Jerry and I really focused on, well, many things, but really 2 points there. One was, well, we came out saying, yes, we do think you should ratify it, and explained that we both well knew that there were easier ways to address the problem, more efficient ways to address the problem, that if we had had our druthers, we would have negotiated a more efficient solution. But the fact was that the negotiations weren't a negotiation between MSF and Oxfam to see who could provide the most elegant and simple outcome. We were negotiating with the United States of America and the European Union, neither of whom was particularly keen on a simple solution. And we got really, I thought, a rather successful outcome on the 2 main points that we had been negotiating. The biggest one was the so-called scope of diseases issue, where the United States and the EU wanted to limit the solution only to treatments for HIV/AIDS and perhaps malaria and tuberculosis. And we had insisted that it wasn't really realistic to ignore cancer and diabetes and the myriad other diseases which people get and for which they would need solutions. So we got an open-ended solution on scope of diseases. The other had to do with eligible importing countries. And again, both the US and the EU had tried to restrict the scope of the solution, and we were successful in avoiding that. Now, the solution does have administrative hurdles and requirements for those who deal in the pharmaceutical sector and industry. We are so used to complexity in that industry, when one looks at the few bureaucratic requirements involved in the process, one is tempted to say, well, if you're really dealing in the pharmaceutical sector, these shouldn't be considered major issues. But in any case, we recommended, and I would even say the same thing today, that there was no better solution to go back and renegotiate. I mean, we had pushed the United States as far as they were going to be pushed. We got as good a solution as we were going to get. If you wanted a solution, that was the one. If you didn't want a solution, you could reject it, but we recommended the EU take it. In that same article, Jerry had principally promoted this idea of regional pooled procurement, because again, as I'm sure you all know, one of the problems with both the paragraph 6 solution and compulsory licensing in general is you need a certain level of economies of scale in order to make this institutional mechanism effective. And one of the ways to get the economy of scale is to create a regional mechanism, whether that's either under the paragraph 6 solution or not. Now, the headline of this talk, I've probably already used my 10 minutes and I haven't even gotten started, is use of compulsory licensing post-Doha. And we really do have the hard data, so this doesn't have to be a mystery. Elena Tone, Birgit Tobes, Hans Hergesal et al. In the WHO Bulletin in 2018 published a comprehensive list of all uses of compulsory licenses, including the paragraph 7 solution, which is a solution that says an LDC can disapply patents and market exclusivity. And Carlos Correa and I, at some point through UNITAID and UNICEF, had prepared forms for least developed countries to use in procurement mechanisms, and that was used quite a bit. And the major licensing took place in 2004, 2005, 2006, kind of at the height of the AIDS pandemic, and there were quite a few licenses issued during that period. More recently, there have been fewer. I think it's not realistic to say that compulsory licensing has been a major institutional mechanism for overcoming patent barriers in the sense of that much use of that mechanism as such. Where we've seen a major effect, of course, is in the political push, I would say that the possibilities for compulsory licensing played a major role in the formation of the medicines patent pool. The medicines patent pool, which was the reaction to potential compulsory licensing, has played an enormous role in increasing the availability, in particular, of HIV medicines. Now, there are real problems with compulsory licensing in general. Number one, it's costly and inefficient. For example, one of the best known cases of a compulsory license is the license issued to Natco in India on Nexavar, a Bayer product, an anti-cancer drug. But if you talk with, and I've talked with the president of Natco about their experience in that, he said, listen, that was very expensive. It took us years. Are we encouraged to go do that more based on that experience? Well, it's rather inefficient and kind of difficult. So we might have some hesitation in that. Apotex might say the same thing to you about the Canadian experience. The major problem with compulsory licenses is simply one of political economy, and Jerry and I had already written about that back in 2005, 2006, which is if you look at any prospective issuance of a compulsory license, it's greeted by political pressure from the U.S. Trade Representative, from the European Commission. We saw that recently in the case of Colombia, where their entry into the OECD was threatened because they were proposing essentially to issue a compulsory license. So it's not a step you can take without expecting your Ministry of Finance to come to you and say, do you guys really want to do this? Because we're going to face the wrath of the U.S. Treasury if we issue a compulsory license. So you've got the political economy problem. During the discussions of the UN High-Level Panel on Access to Medicines, through the International Law Association Global Health Law Committee, I was on the expert panel for the high-level panel, but we also submitted a proposal for something we called an effectively automatic compulsory licensing license for essential medicines. The notion being if you were on the WHO essential medicines list, you'd be entitled to a license, and then a royalty would be defined. Ultimately, the high-level panel did not accept that and got some pushback from some unexpected places about the legal analysis of the possibility of creating what we described as an effectively automatic compulsory licensing mechanism, but that was a fairly recent effort. I would point your attention, Xavier Sueba, a good friend of Dr. Grosse, sitting here in the audience, has written about the European Union's very recent adoption of a regulation allowing the export of medicines under protection by a supplemental protection certificate to countries where there's no patent protection, which is of interest both because they're effectively allowing compulsory license, I won't call it that, but whatever it is they're doing, a waiver of patent protection for export, which is precisely contrary to the position they took during the Doha round negotiations. Well, there's a great deal more that could be said about this, but we've got a brilliant panel here who go into some of the more modern aspects of this in detail. This is a little bit of a historical perspective, I think, something Jerry and I have been worked on for a very long time together. I think both of us are concerned. We both like innovation, but neither of us want to see patents act as a death sentence for anyone if we can prevent it. Thank you.
Thank you, Fred. And the next up is Professor Brook Baker, and I'm going to help you do a quick switch on the machine.
Okay. Okay, so it's great to come after Fred because what I'm going to talk about was in a sense suggested by some work that both Fred and Jerry did back in 2007. As Fred just suggested, the problem with compulsory licenses in general is that they're single market licenses. And if you're a small country or a poor country, then the incentives for a generic company to take up the license, and particularly to produce a new medicine, but even maybe to come in and produce and sell a medicine that they already have, is greatly reduced. And the entry of a single competitor doesn't necessarily do a lot to lower prices, because we know that in many markets, a single generic entrant or even two or three entrants does not necessarily result in the kind of price competitive activity and economies of scale that you want. So what you really need to have an effective compulsory licensing system is large aggregated markets with purchasing power. And that is not something that's accomplished easily in country-by-country negotiations. I'd say that the problem is perhaps even worse with respect to the new biologics, and I want to spend some time to talk about the special problem of compulsory licenses on biologics. But I do want to, tip my hat to the early work that was done that suggested there needed to be some kind of mechanisms, and they talked a lot in a paper, or actually a relatively short discussion, of the idea of combining this idea of coordination of compulsory licenses, pooled procurement, and they even wanted to, if possible, locate some new manufacturing facilities in low and middle income countries, and preferentially in least developed countries, because those least developed countries would not have to respect any pharmaceutical patents if they adopted the WTO LDC pharmaceutical waiver. I think we've already heard from some other presenters that the world we're entering is much more dangerous with respect to access to medicines. I really appreciated the discussion of what's going on in India and the fact that we are going to have an entire generation of every single new chemical entity pharmaceutical patent being processed in India, and most of them granted. And so India, which is this major source of generic medicines for many countries, not just for HIV, but for many other conditions as well, will have blocking patents. And of course, there will be blocking patents in many of the countries that might need it. So you'll need a two-patent operation of two patents, a patent in the country of importation and use and a patent in the country of production and export. And again, that's not easy to arrange if it's a single country situation. So what we need to think about is what they suggested might be needed, which is developing a mechanism to aggregate the markets and coordinate the issuance of compulsory licenses. So perhaps to incentivize generic entry for a new product, or at least to be able to take advantage with respect to an existing product. The existing product, if you look at the database that Fred just talked about, virtually all the compulsory licenses that are granted incentivized sale of generics that are already being produced. They weren't new medicines that were developed by, or new generic versions that were developed by companies in response to compulsory license. They were already selling in other markets. And they were in the compulsory licensing country was basically able to take advantage of generic production which already existed. But to incentivize a new generic entrant who has to go through all the product development process, has to go through the complicated process of registration, and has to see if there's market potential that really works, that's a real problem. And of course we have, I think, a change from the circumstances that they were worried about. The success of the medicine patent pool is that, especially for HIV medicines, 90% of the people living with HIV are getting access to voluntary licenses. The countries that are excluded are upper middle income countries. So initially people thought that a lot of the problem with respect to access might be access in low and lower middle income countries. But in fact, right now, and significant gaps of access are in upper middle income countries, in the so-called farm-emerging markets. Brazil, India is typically included, but certainly China is always excluded. And so the higher prices charged in those countries, and they're not having the possibility of being included in voluntary licenses, has created a special need for access in upper middle income countries, which again, only compulsory licensing could potentially overcome. So, some of us worked on an idea for the high-level panel that Fred talked about. We submitted a proposal for the establishment of a compulsory licensing facility. Basically, a facility that would do something like what the medicine patent pool had done with respect to voluntary licenses. And people may remember that in the history of the medicine patent pool, there was a period of time when people were talking about whether it should be both a compulsory and a voluntary licensing facility, whether it should have a stick in one hand and the inducement of something voluntary in the other hand. That the idea was defeated, and perhaps wisely so, but it's left the compulsory licensing possibility with very slim resources. The only international entity that I know about that gets government funding that has any mandate to directly work on compulsory licenses is UNITAID. UNITAID in its constitution has a provision to support countries in their use of TRIPS flexibilities to access medicines, and specifically mentions the inclusion in the Constitution, mentions compulsory licensing as well. So there would be some prospect for going back to UNITAID, which is the only funder of medicine patent pool at this point, and perhaps seeing whether we could establish a facility there. I'd have to say I was working for, I was the NGO rep to UNITAID for 4.5 years and worked very hard to have them develop an intellectual property strategy and tried to get them to become interested in compulsory licenses. And as you can imagine, the powers that be, the US, even though it's not part of UNITAID, was jumping up and down. UK and some of the other European entities were also highly unenthusiastic about talking about compulsory licenses. So it's not going to be an easy prospect even there. But the need for a facility that would work on coordinating on several levels is important. Now, I may not even use my slides at all, but there are still many open questions about compulsory licenses that we don't know. Is it a good idea to issue compulsory licenses on pending patents? We know in many jurisdictions that patent grants take a long time, but they actually deter generic entry even during that period of pendency. And in some countries, there's a risk of retroactive damages for patent infringement once the patent is granted. So do we need, we need to investigate, I think, a little bit further whether we shouldn't have, become more comfortable with the idea of patents on pending patents. We have never discussed in a very serious way, I think, the issue of how you get multiple entrants, particularly where a negotiation is required. So if you've got an all-sector compulsory license and there's a requirement of prior negotiation, does each potential entrant who wants to take up the license have to engage in an independent voluntary negotiation with the patent holder to be able to take advantage? There are a couple dozen questions like this that we still have in the compulsory license space, and it'd be good to have a dedicated facility that was going to look at those issues, and then in the end probably come up with some model legislation, because most countries at present have terrible legal regimes for granting, for both the grounds of compulsory licenses and for the procedures for issuing them. And then in addition to doing that research and think tank kind of work and coming up with model legislation, you'd want an entity that could happily even work with countries to help in the coordination of the issuance of the licenses. Now, one of the things I found really interesting about our conference so far is that it provoked so much thought. So I thought this was going to be pretty much the content of my presentation, but I've actually shortened this because I now think in the medicines context, the problem of biologics is huge. And compulsory licensing is not a compulsory license with respect to the patent only is not a good solution. Because if you still have to redo an entire cell line, if you still have to undergo all the expensive clinical trials, if you still have to go through all the regulatory processes and have an expensive plant built, you don't get the same cost savings. So, and I think in kind of the background of this whole meeting, there's been this idea that trade secret is really a huge problem now in the IP space, international IP space, that we may not be paying enough attention to. And the industry is taking huge advantage of what they call trade secret to essentially have perpetual monopolies. Now, I was actually concerned in Artie's presentation just a little bit because you spoke with biologics as a natural monopoly, but it's only because they can maintain their secrecy with respect to their cell line. They have the proprietary right to continue to keep it secret. Well, we can imagine a legal regime that would say, you may have some period of time to earn back your investment, but it's not into perpetuity. You actually have to give the cell line. You actually have to give the manufacturing process. At some point, we let the interests of society with respect to essential public goods like medicines to have more weight than the confidentiality interests of the commercial entity. So why aren't we thinking more about using ideas like compulsory licensing for trade secrets, for manufacturing know-how, for even for access to the cell lines themselves? Why isn't that something we're talking about? And of course, we know that the counter move is that, the industry is pushing data exclusivity. And there's a deficit in the legal regime at present that most countries do not currently recognize something like a compulsory license to data exclusivity, or in other instances, even when there's not a patent in place, is there a right of public access to the data for purposes of registering the generic entrant? That seems to be an easier argument to make at this point than the overall trade secret argument, but seems to me it's very much related, and that one of the things we should be thinking about, and that such a facility could help work on, is expanding the utilization of something like compulsory licensing to gain access to all of the information needed to actually make cheaper medicines, to make equivalent medicines, either generics for small molecules or bioidenticals, rather than simply biosimilars for biologic medicines. The question in part is, will countries cooperate? Because the pressure from the rich countries is so harsh at this point, and industry jumps up and down every time. Can there be political will? And I think one of the advantages perhaps at this point is that the countries that are feeling the heel of the monopolies on medicines most intensely, at least in some areas right now, are the farm emerging, some of the richer upper middle income countries. And they may have the political clout, they have an existing BRICS arrangement whereby they could begin to think about what can we do to cooperate together to actually overcome these monopolies that are preventing us from providing the new medicines to our populations. So anyway, the proposal is that we come up with better thinking about how to set up a mechanism that actually supports the theorizing of, the coordinated use of, and expansion of compulsory licenses to ensure access to medicines.
Thank you. Thank you, Brook. And our next speaker is Kat Geddes. And did I pronounce Geddes right? And I will again assist Kat to make for a quick transition on PowerPoint. So.
Hi, everyone. So I wanted to talk about the HIV epidemic today because for many people in the access to medicine space, the HIV epidemic marked the start of their careers in access to medicines. The devastating mortality rates have often been referred to as one of the starkest examples of the impact of pharmaceutical pricing. As a result, the evolution of legal and policy responses to the HIV epidemic have shaped much of the subsequent history of the access to medicines movement. Many of those policy and legal responses guided by Jerry's work. And so we arrive at our current situation, which is that 60 years after the first reported cases of HIV, we're still facing many of the same obstacles to access, which reflects not only the prescience of many of Jerry's early insights, but unfortunately the fact that not that much has changed. So before I jump into the case study, I want to situate it within the context of Jerry's very extensive scholarship on non-voluntary licensing, specifically this article that he co-authored with Catherine Hasensaal in 2003. So Jerry reminds us that non-voluntary licensing is a double-edged sword. The ability to grant a compulsory license doesn't necessarily mean that it should be. Often the mere threat of a compulsory license can be sufficient. This observation is consistent with the work that I have been fortunate to do over the last 2 years with Terry and Ruth, working with governments in sub-Saharan Africa on patent law reform to promote access to medicines. In situations where we've been asked to provide advice on how to clarify or streamline the statutory language around compulsory licensing, often the objective has been not necessarily to issue a compulsory license, but to ensure the legal capacity to do so that the threat of issuing a compulsory license is credible and that can be leveraged within voluntary licensing negotiations. The objective always being to maintain positive relationships with the pharmaceutical companies that are providing much needed drugs to these poor countries. So my biggest takeaway from this article when I first read it was Jerry's comment about the importance always of focusing on the coherence of the overall system. Often, excessive reliance on compulsory licensing can mask deeper structural issues, and this is something that we should always bear in mind when discussing the issue of non-voluntary licensing. I also want to situate the case study within the context of Jerry's article on compulsory licensing from 2009, where he reminds us that the conspicuous absence of compulsory licensing on pharmaceutical products can be attributed to many different factors. Threats, as Brook mentioned, from powerful governments, provisions, TRIPS Plus provisions within bilateral and free trade agreements, and specifically big pharma's misleading and self-serving interpretations of the relevant legal instruments. I wanted to highlight this particular phrase because when I was doing research on this case study, it struck me as particularly prescient. Earlier this year, in response to activist campaigns to break the patent on Truvada, HHS Secretary Alex Azar stated publicly in April that there is no such thing as a legal right to break a patent within the United States, which is obviously demonstrably false. Unfortunately, as a former pharmaceutical lobbyist, Alex Azar's comment is not surprising. Unfortunately, given his current position, it does lend his statements government authority. So this is something else to bear in mind. And then obviously in the article, Jerry also reminds us that despite the many reasons why a lot of compulsory licenses haven't been issued in cases where it would have been helpful, there have been some brave governments that have done so. And then finally, some takeaways from this article that I wanted to highlight again as we begin to look at this case study are that the so-called social costs of issuing compulsory licenses are often exaggerated. For example, the argument that they lead to reduced foreign direct investment. China is a great example of the falseness of this argument, and the idea also that patent protection leads to investment in drugs for diseases that affect developing countries, neglected tropical diseases being a great example of the flawed nature of this particular argument. So the drug that I want to focus on today is Truvada, which the FDA approved for use in pre-exposure prophylaxis, so HIV prevention, by taking one pill a day. So just to go through the history briefly, as I said, it was approved by the FDA for PrEP in 2012. Dr. Robert Grant, who was one of the main researchers leading clinical studies on the efficacy of PrEP for this purpose, mentioned in an interview with the New York Times that one of the reasons why Truvada had been chosen for clinical testing was because people that he knew at Gilead had said that the drug would be off patent by the time clinical trials ended. Unfortunately, this was not the case. Gilead donated Truvada for use in the trial. The trials were funded, however, by $50 million in federal grants and $17 million from the Gates Foundation. Gilead continues to charge at least $20,000 per year within the United States for a drug that costs much less to produce. In 2018, their global sales from Truvada amounted to $3 billion. In response to a lot of activism and negative publicity, Gilead offered a series of Band-Aid solutions, 200,000 free doses, and 1 year early access for one generic company, Teva Pharmaceuticals, which will be able to provide generic Truvada as of September next year instead of 2021. Obviously, activists were not impressed by these Band-Aid measures, and access to a drug as critical as Truvada should not depend on the charitable whims of a giant pharmaceutical corporation. The other thing to note in terms of early access for Teva is that the kind of price reductions that are associated with generic competition are usually only seen after many entrants enter the market, not just one. So In response to a lot of negative publicity, the House Oversight Committee held a hearing on Truvada pricing in May this year. It didn't amount to much, although some sound bites of Alexandria Ocasio-Cortez challenging the CEO of Gilead on why the price in the US is $20,000 and why the price in Australia is $8,000 went viral on Twitter. Apart from that, not much happened. A lot of the break the patent activism has focused on the idea of march-in rights under the Bayh-Dole Act. Unfortunately, historically, the NIH has been very reluctant to exercise march-in rights, and so that hasn't really gone anywhere. The other option that has received a substantial amount of scholarship is the idea of a government use license under Section 1498. And Amy Kempinski and others have done a lot of great research on this. It has almost been used in the past, so a lot of you might remember that immediately after September 11, the US government threatened to issue a government use license on ciprofloxacin in response to the anthrax scare. They didn't actually issue the license. Bayer got scared and halved the price, and everything was fine. In 2017, Malaysia issued a government use license for Gilead's Hep C drug, and in the wake of this, Louisiana Health Secretary Rebecca Gee publicly considered invoking Section 1498 for access to Sovaldi within the state. This received a huge amount of press attention and obviously criticism from the pharmaceutical industry, and unfortunately is dead in the water. This summer, Louisiana revealed that they had agreed on a new, what they're calling their Netflix subscription model, where Gilead would provide them with an unlimited supply of Harvoni at a different cost. But basically, all of the excitement that activists had attributed to the idea that finally we would issue a government use license for something that was exorbitantly priced, unfortunately didn't go anywhere. So we arrive at the current situation, which, as you can see from the stock price discrepancy, is that patented Truvada continues to be extremely expensive within the United States. It costs $20,000 per year. In Australia, generic Truvada, which is subsidized by the Pharmaceutical Benefit Scheme, only costs $480 per year. This has received a huge amount of press and attention from politicians, including current political candidates for 2020. Actually, a week ago, Kamala Harris revealed her plan for access to PrEP, which didn't receive a huge amount of press, but just indicates that this is currently part of political discourse. Some of you may know Jonathan Van Ness, who is a famous celebrity from Queer Eye. He endorsed Elizabeth Warren actually 2 days ago on the basis of the the ongoing high price of HIV medication within the United States. So, in conclusion, could compulsory licensing finally end the HIV epidemic? A lot of activists have talked about the fact that despite a steady decline in HIV infections within the United States over the last 5 years, that decline has actually stalled at about 39,000 infections per year. People have discussed this within the context of maybe if PrEP was actually affordable and we didn't have to wait for generic versions until next year, then we could finally end this epidemic. While there is some merit to those claims, obviously PrEP is not a magic bullet. The price of PrEP is not the only barrier to ending the HIV epidemic. And as I've just shown, the US has historically been extremely reluctant to issue a compulsory license. Other measures in other countries have been successful in providing citizens with access to PrEP. Patent opposition in Argentina and Brazil, for example, has been very successful. It's important to note that although PrEP has demonstrated great efficacy, a 99% reduction in the risk of acquiring HIV through exposure if people take 1 pill per day, sustained PrEP coverage among men who have sex with men will still avert no more than 50% of new infections over the next 20 years. Basically, we need to have almost full coverage, herd immunity, in order for the epidemic to actually show signs of abating. Other non-price barriers that I also need to bring up within the context of the epidemic include homophobia, transphobia, what people are calling slut shaming. So because PrEP allows men who have sex with men and other at-risk populations to engage in unprotected sex. A lot of people have stigmatized the use of PrEP because of this idea that it leads to sexual promiscuity. So again, PrEP is just one component of a comprehensive HIV eradication strategy, and unfortunately the US historically has demonstrated significant reluctance to issuing a compulsory license for this purpose. Thank you.
Thank you. Thank you. Our next speaker is Henning Ruse-Khan, and you want me to help you on the slides, or?
Let's see if I can work it out. Okay, well, so, again, I probably also have to thank the organizers, especially Ruth, Justin and Irene for having me here. And of course, thanks a lot to you, Jerry, for basically, being generous with all your ideas and effectively putting out these ideas, especially in the context of compulsory licensing, which is the focus of this panel. My focus sort of shifts a bit from the substantive rules and that number 31 to a few numbers up in the TRIPS agreement, 41 upwards, on the enforcement-related provisions of the TRIPS agreement, and whether they provide a real alternative to perhaps issuing compulsory licensing. Now, when I say real alternative, I'm not really talking about the policy and whether and when it makes sense to look into judicial compulsory licensing or effectively not granting injunctions and instead perhaps providing just compensation, but I'm more interested in the legal constraints on the international level to the extent to which effectively this is possible. So what I'm focusing on essentially is that the question that because granting or not granting in particular an injunction and instead just awarding compensation can effectively operate as a compulsory license. So you're shifting from a property to a liability rule, something I think we'll be addressing a little bit more in detail later on. So the question then is, what, if any, limits do in fact under international law apply to the discretion of a domestic court to decide whether or not to grant an injunction, right? So, and I'm going to look at Article 44 of TRIPS, the specific rule on injunctions, then the general enforcement of the TRIPS, general provisions on enforcement under TRIPS, especially Article 41 and 42, and then perhaps as a sort of default mechanism operating or regime operating in the background, concepts under customary international law with regards to questions of denial of justice, and finally raising the question whether the substantive patent provisions, but in this case particularly Article 27 and the non-discrimination rule, have anything to say on the operation of the flexibilities under the enforcement provisions. And in fact, if either you guys might be sort of too bored to listen, or you're too tired, or I don't get the time to address this, you just read Jerry's stuff and it's basically covered there, because effectively the flexibilities are far-ranging and little, if anything, is from the outset prevented by the international system. Kat already mentioned one or two of those articles. I don't need to talk about them in any detail, just to say that Jerry has not only written about the compulsory licensing substantive provisions, 27 and perhaps Article 5A of the Paris Convention and so on, but also has addressed the flexibility under the enforcement rules. And one of the, I think, for me, most favorite quotes, which I always use in my slides teaching international IP at Cambridge, is where he says in an article with Lange from 1998 that right holders, he predicts, or they predict, that right holders will be disappointed with the operation of the enforcement provisions under TRIPS. And the reason perhaps for that is that those provisions do provide much more flexibility than those who had hoped for a relatively rigid regime with regard to the enforcement under the TRIPS agreement actually were achieving. And that's perhaps also the reason why we have a strong focus on IP enforcement in free trade agreements and having a lot of much more specific and detailed provisions on the enforcement of intellectual property rights in that context. So to start with Article 44, right? So Article 44 on injunctions in TRIPS has two sections, and it's important to distinguish, right? So the one which probably most immediately jumps at you when you focus on compulsory licensing is Article 44, Section 2, which more or less says that keeping in mind the provisions under Article 30, which, one of the TRIPS agreement with regard to the use of patented invention by governments, including the use authorized by governments, and subject to paying remuneration under Article 31H, judicial compulsory licenses are possible. So that's one thing. Now, another thing, and that's perhaps of equal, if not broader importance, is that generally the question of issuing an injunction is something where, under Article 41, judicial authorities simply must have the authority to do that, right? So that's something we have to perhaps look into, what that notion of shall have authority actually means. First point on Article 44, Section 2, judicial compulsory licenses, that's probably also one of the few TRIPS flexibilities which is specifically coming from US practice and which is based on particular notions in US law, where, at least from what I heard from Jerry, compulsory licensing, if you want to call it that way, is done all the time when it comes to government use, especially in the military sector, right? Now, there, the key question perhaps is what amount of compensation is to be owed for a particular invention which has a particular role in a more complex product. But the basic rule under Article 4 is, Article 44, Section 2 is, you can have a judicial compulsory license subject to providing that adequate remuneration, where under Article 31H, I guess, again, there's significant flexibility to determine how much is to be paid. Article 31H says, I think you have to take into consideration the economic value of that license, but it doesn't tell you exactly, or it doesn't further prescribe in detail what needs to be done. So you can issue compulsory licenses by the judiciary in government use cases, no problem. Now the next thing then is under Article 44, Section 1. What, if anything, does constrain the ability of a court to decide when to issue an injunction and when perhaps not to do so? Most of you will be familiar with the eBay versus Merck exchange for factor tests, where you already have quite some flexibility. You have similar approaches to some extent in the UK. Other countries like Germany, for example, in the patent context, take a much more rigid line, which seem to assume that there's an automaticity. Once the patent is infringed, automatically injunctive relief must follow, regardless, and that's probably somewhat problematic, and as I would argue, in no way mandated under TRIPS, because if you look at what is required under this shall have authority obligation, we have a bit of guidance from a panel report in relation to the China case. So this is the China IPR's case where the US complained about China's border enforcement rules, which allowed China's customs authority, when they had identified trademark counterfeit goods, to offer them to charities, to auction them, to sell them back to the right holder, or to destroy them. So they had a range of options in their domestic law. And the US argued this is in breach of Article 59 of the TRIPS agreement, which refers you back to Article 46. And again, the question is the obligation to have authority to order the destruction of the goods in this way breached here because China offered more than those particular options. China not only offered destruction, but other options as well, right? And the panel in this regard decided that, and that's important because this notion of shall have authority appears basically all over the TRIPS agreement, right? So that obligation does in no way mean to exercise the authority in a particular way, right? You would assume that from the reading, but it's confirmed. And the panel also emphasized that in that regard there is significant discretion. So the key question from me against that background probably is then, is there anything that limits this discretion, or is that complete discretion for national authorities, in particular courts, to decide that, right? Just to reiterate maybe on this, that also in free trade agreements, while we have much more detailed rules and enforcement, they usually apply the same notion of shall have authority. Hardly ever, there are some exceptions, but hardly ever this notion of shall have authority is being modified. So also under FDA enforcement obligations, it's usually that, be it customs authorities or courts, it's an obligation that they have to have an authority to do something. So is there any further than constraints on that discretion, on that flexibility? Now, if you look into the general enforcement provisions of TRIPS, you might say, well, Article 41, Section 1 talks about effective remedies. So you have to provide remedies in your domestic law which allow effective actions against infringement. Okay, I'll hurry up. Like I said, otherwise read Jerry's articles. Now, that, however, is to be balanced against not interfering with legitimate trade. It probably doesn't really speak to this particular consideration, but just to say that effective action is not the only and sole maximum of enforcement protections. Then to move on, Article 42 talks about enforcement remedies being fair and equitable. And Article 41, Section 2 and 3 further provide some guidance on how generally states have to deal with enforcement obligations. But all of that is essentially about due process and does not speak to the substance of the judgment. And that, again, is confirmed by general international law. If you look at notions of denial of justice, if you look at, for example, the International Court of Justice, or even investment treaty arbitration, take Mondev, don't go to Eli Lilly versus Canada, because that's rubbish in terms of what they said about denial of justice in there. But if you look at that, it's essentially a due process test. It's not a test which allows you to review the substance of the judgment. And with that, I would say, maybe there's an argument to say, well, if say, you have injunctive relief in your in your procedural code, but in practice you never ever grant it, and it's arbitrary that you don't do it, well, then you have a mechanism perhaps either under TRIPS or general international law to constrain that. Other than that, I'd say basically you have flexibility. Last word, a question might be raised whether the enforcement-related obligations are also affected by Article 27. So if you were to have an enforcement regime where injunctive relief and granting injunctive relief was somewhat conditional upon, say, a factor which looked at local working, right? Then the question could, of course, be whether that local working effectively operates as a discrimination between products which are imported and locally produced. But I'd say that Article 27, being in the substantive provisions of TRIPS, doesn't necessarily inform the interpretation of Article 41 onwards, but one could discuss that, I suppose. So and to conclude, I'd say Jerry was right. We have lots of flexibilities. It just needs to be used. Thank you.
Thank you. And our last panelist, before we have some Q&A, is Jayashree Watal, who will talk to us about special compulsory licenses for export.
Yes, thank you. Sweet of you. Yeah, that's it. Yeah, there it is. Okay. I'm okay. Yeah. Hello, everyone. Last speaker on this panel. It's always a bit intimidating, but first let me thank Ruth for inviting me, and Ruth, Irene, and Justin for organizing this, for Jerry. Totally well-deserved. As I said yesterday, Jerry, you were my mentor. Nothing to take notes about, just that you were my mentor, and you will continue to be. Okay. And you were also the first. Now, everyone's talked about how they've cited Jerry. I'm very proud that Jerry cited me. That's a bit egotistical, but that's what I'm proud about. Okay, so let me start. This is something which you all know about. So it's just a graphical view of the basic rule, which now is exempted under Article 31 bis, which is that the use of compulsory license should be predominantly for supply of domestic market. That is, of course, now not any longer applicable, provided the terms and conditions and the transparency, safeguards, etc. are met. Now, my critical review of this is, there's been a lot of criticism. Fred already spoke before me that the scope is not restrictive, and I would agree with that, because the definition of pharmaceutical product is quite broad. I'm just putting it out there. The only question was about vaccines, and that did come up in the negotiations. In fact, Japan raised this point and said that vaccines shouldn't be included. One was the only one who said vaccines shouldn't be included, and nobody really picked it up. And immediately after the negotiations, the waiver negotiations, Pascal Lamy, who was at that time Trade Commissioner of Europe, came out and said vaccines are included. What about eligible participants? There again, Fred said not really restrictive on importing members, no restrictions. However, a more flexible attitude was only shown towards LDCs, because LDC members are the only ones automatically eligible. Every other member has to make 2 mandatory notifications to the WTO, and those can be made at the same time, but there is that notification requirement. However, these notifications are only for information, not for approval by any WTO body. 33 members voluntarily opted out from using the system. 11 members voluntarily opted out partially, use in emergencies only. Actually, it's very important that they did this partial opt-out, because it tells us that it's not to be used only in emergencies, which a lot of people say it can only be used in emergencies. The fact that 11 said we will only use it in emergencies means everyone else can use it even in non-emergency. So that's the list of countries in the chairman's statement. One weakness, non-WTO members were not mentioned as input because they were not around the table. However, in implementation, almost all have included non-WTO members, all the major ones, and some have been silent on it. Exporting members, no restriction at all, even though the United States wanted it to be restricted to actually those that had generic production and so on, but that was not the case. But it's optional as importers, optional as exporters, and the United States was the first to ratify, to accept the waiver as well as the amendment, saying that we will never use it either as importer or as exporter. So it's subject to these transparency and safeguards and so on. So how cumbersome are these safeguards? Because a lot of people say, oh, these are extremely cumbersome. And Fred did say, well, they're not all that cumbersome. So importing members shall take measures to prevent re-exportation. This is the one which is a shall, it's an obligation, and everyone says, oh my God, they have to do something about this. This was heavily negotiated, and these are the caveats. These measures must be reasonable or have to be reasonable within their means, proportionate to their administrative capacities, and all this is cumulative. Reasonable within their means, proportionate to their administrative capacities, and proportionate to the risk of trade diversion. So really quite meaningless. I mean, I'd like to see a dispute on this. And in addition, if somebody is accused of not having taken these measures to prevent re-exportation, the developed country members shall, upon request, make available technical and financial cooperation. So, as I said, heavily negotiated, quite meaningless. So, what is actually a cumbersome obligation, or at least something that has to be done? That is on exporters. The exporters must make special labeling or marking. This is the only obligation, special labeling or marking. Have you seen any medicine exported, whether in bulk or in as formulations, without any labeling or marking? That rarely happens. So you must have some special labeling or marking. And Canada, for instance, mandates that the marking should be XCL, logically export compulsory license. So that's not very complicated. So what about the notification requirements? Are they really difficult? Are there bureaucratic requirements that are difficult, let's say, for poor countries and so on? What is the notification requirement? First use, I intend to use the system, that is as an importing member, and the details of each use. Both can be done at the same time. Exporting members, what is there? A little more in terms of the notification requirements. Whether the exporting members have granted the CL, they have to, of course, grant a CL because that's the only way this will work. So you grant the compulsory license and then you put conditions on that. So all that has to be notified. The details of the license, the name, I am not reading that out, website. And all of this is made for information purposes only, no need for approval by anybody, any WTO body before using the system. In addition, in case you can't do this, the WTO provides a guide on notifications. This is the website or the URL for the guide, and it's basically got model notifications where you fill in the blanks. The blanks being the name of the country and name of the product and so on. The chairman's statement was also controversial. Now, I won't go into the aspects of what is the legal backing, what is the legal validity of a chairman's statement. The chairman made that statement twice, and the chairman of the General Council made the statement twice before the waiver decision was adopted and before the amendment protocol amending the TRIPS agreement was adopted. Now, this gaveling before the adoption and gaveling after the adoption has some legal significance, which I leave it to you guys to figure out. Well, I'll just tell you that it's it was very heavily negotiated, only between five. The WTO had, at that time, probably 160 or so members. Only 5 were involved in this negotiation. And what does it just say? It represents key understandings, shared understandings, that the system shall be used in good faith, that the only word added was all reasonable measures should be taken to prevent diversion, and that how manufacturing capacities were decided would be notified or would be explained if asked, and that there would be an expeditious review if there were problems and so on. And then, of course, it also contained the list of the opt-out countries. How has this been implemented? It's been implemented by developed countries, you can call them industrialized countries, countries in transition, as well as developing countries, and LDCs. Now, countries that have implemented the measures cover about 85% of the world's export markets, and Roger Kampf, my colleague at the WTO, when I was at the WTO, has actually written a working paper on this, and a lot of this presentation comes from him, including this map, which shows you which countries have actually implemented the measures. Some have done it exclusively, only for export. You see Australia, Canada, etc., only for export, Switzerland also, and only for import, and then limited to emergency situations or extreme urgency situations, and so on. Then there are others who have done it for both import and export. As I said, US says they will neither do it for import or export. Diseases, what have most of the countries done when it comes to implementing this? They've just referred to public health problems without any limitation. What about products? Do they cover also process patents? Yes, most of them. And the EU, of course, covers the SPC, and the patents as well as SPCs. And some laws explicitly cover active ingredients and diagnostic toolkits, others don't. On the eligible importers, WTO members, of course, and LDCs who have notified, LDCs and others who have notified, but a majority of them also include non-WTO members. Now, where would non-WTO members notify? Because there's a notification requirement. So where would they notify? They would notify, according to Canada, to the Ministry of Foreign Affairs of Canada. And that is enough for them to be recognized. Now, legally or technically speaking, the waiver would not apply to such, but nobody is really taking a dispute on this. The pre-grant conditions, almost all measures, and here, this is the weakness. If there's one major weakness of the system, the 31bis system, it is that 31B was not waived. So the double remuneration was 31H, that was waived, but 31B was not waived. So what does that mean? It means that everyone who wants to use this, if there is a compulsory, if there's a patent both in the importing country and exporting country, there has to be a prior request for a voluntary license. And that Canada got around that by saying, let's give a very short period of time, 30 days. And that's one way of doing it. There's nothing here which says what should be the reasonable time. So you could say 30 days. So that's where the quantity, there are some limitations in terms of the notification by importing countries. It has to not exceed the notifications by the importing countries. However, there can be several importing countries that notify jointly. So you can actually have what Brook talked about, the economies of scale. The economies of scale question can be addressed in a certain sense with the joint notifications. There are in some laws, and this is not a TRIPS requirement, but some laws have limited it, well, I suppose it is a TRIPS requirement because it is in Article 31, limited to the purpose for which it was granted. But if the purpose was broad, like public interest or something quite broad, then there is no limitation. Any case, I won't go through all of this. There's remuneration. Some have actually specifically said how they will calculate remuneration, for instance, the Canadian law. And again, one more weakness, time is up, okay. So one more weakness is the fact that some countries have added regulatory approval before exports, because many countries do not actually approve of products which are not sold in their countries and which are meant for export, but that some have added that. So what do I just say about the use of the system? Yes, everyone knows it's been used, hardly been used once, Canada, Rwanda, which was also an artificial case. It was not actually a real case, and I'll tell you why if you want to know. But to my mind, it will be used, and it will definitely be used when there is a global pandemic. Fortunately for the world, it hasn't happened. We've come near it, but we haven't had that. So let me not waste any more of your time. I have some points, but you can look at the presentation. And with that, I would actually like to have more time for discussion, because I also have questions to ask of the other panelists.
All right. Thank you very much, Jayashree. And I want to thank all the panelists for staying pretty close to our times. With my co-organizers' blessing, we'll take probably 5 or 10 extra minutes on this. Our next logistical part, I'm getting emails from Ruse-Khan. I don't think she's in the room right now. Professor Fisher, you had your hand up. But before we do, we always let Professor Reichman decide whether he begins or closes. Are you the closer or are you the opener? Do you want to open or close, sir?
Both.
Or both if he wishes. Of course, Henning gave him a microphone that doesn't work. That's clever. All right, Terry, go ahead.
One of the recommendations that the high-level panel did adopt was the extension to the context of compulsory licenses of that general principle, namely adopting on some multilateral basis a prohibition applicable both to national governments, such as the U.S.
So I think that was directed toward Fred, but the question was, so Terry, as I understand your question, or Fred, do you want to go ahead?
Well, yes, it was, that issue was discussed fairly extensively in the high-level panel meetings. The issue of political pressure as an inhibition on the effective use of compulsory licensing, number one. And number two, the high-level panel did recommend that governments not take measures that sought to intimidate those who were using compulsory licensing, particularly when it's done lawfully. Your specific question is there a realistic possibility of there being some type of multilateral agreement that actually that type of practice would be prohibited? And I mean, to be candid, I would say no, because really the US government has exercised substantial weight in blocking any effective follow-up of the high-level panel report, including, let's say, not acting in the friendliest way possible towards the United Nations Development Program, both in general and in specific. So those who might be contemplating organizing such a response have already been effectively pushed back on that. So it was discussed, it's an idea, it's a good idea. Jerry has talked about this before as well. I mean, Jerry has written about what measures could be taken to constrain the use of political power to prevent taking effective legal measures. But again, there's a difference between is it a good idea and is it going to happen? And
Henning has a quick response also.
Yeah, maybe just to add from a somewhat more legal perspective, that you had, of course, the attempt by the then EC to go after the US use of this kind of pressure, perhaps under the special 301 proceedings, and you had a WTO case effectively saying that this is only legal to the extent that you use special 301 and 301 in order to determine legality under WTO rules, and then you have to actually bring WTO proceedings, because the whole purpose of the DSU, the Dispute Settlement Understanding in the WTO, of course, in principle was to prevent that kind of diplomatic pressure, and that you had the rule of law in order to assess compliance with WTO obligations. But you see that doesn't really help very much, because there's lots of WTO plus stuff out there which you could still use special 301 for, and plus the additional points which Fred made on the more political side. So I think effectively you don't have under the existing system any strong mechanism to prevent that from happening.
We will only have time for a couple more questions. I saw one over in the front here. Yes, sir. Yes, Marquetta, was it you?
Yes.
I'm sorry, you're hidden behind several people.
So I have a question about what we should be looking at and whether we are expecting too much of patent law. So two things, right? Given the expanding economic differences within individual countries, including within the United States, I wonder how the panelists would see the future of patent law and access to medicines within individual country, right? And how some of these problems might play out at the global scale, but within this granular sort of view of socioeconomic differences getting bigger and deeper. And also whether there is any role for patent law or intellectual property law in general with as regards the problem of access to out-of-patent medicines, right? So we have seen an increasing problem of access to medicines that are out of patent. So I wonder what the balance might be.
A quick round of responses to that so we can get into more questions.
What, all of us?
Well, yes, I didn't mean to take 30 seconds deciding who'd speak. Brooke, do you want to jump in? Jayashree, do you want to jump in? Go.
Well, I mean, I think the in-country issue is quite germane now in the US, because we have actual proposals in Congress for use of compulsory licenses in the event that negotiating of Medicaid and Medicare prices are unsuccessful in significantly reducing prices. If you had asked people 3 years ago whether the US was going to have a compulsory licensing proposal from dozens of members of Congress and endorsed by Democratic presidential candidates, you would have said no. You wouldn't have the report from the Labour Party in the UK also championing compulsory licenses. The Dutch government took a lead in this as well. And the reason is we know that the expansion of monopoly power and the escalation of exploitation of the monopoly rights through high prices is making it impossible to achieve access even in the richest countries in the world. And people are literally being rationed out of use of life-saving medicines because of these exorbitant prices. And the people who end up paying the highest actual price are the poorest people who don't have insurance. Actually, of course, they don't pay, they just die instead.
And
So,
short answers.
Short answer. Well, I've been thinking about this, and it's very, very difficult to do differential pricing, which is, the preferred solution for most economists, that why don't we just do differential pricing? But within a country, it's really hard. And I can draw upon my administrative experience as a civil servant in India, where I had to make sure that cheap price, which was only meant for the poor, didn't kind of leak to the rich. In the twin cities of Hyderabad and Secunderabad, and it was impossible because there's so much, where there is reason for the market to kind of benefit from good quality, cheap price, it's going to happen. So it's very difficult to do. However, there are systems like public health systems and private systems, and maybe you could make that distinction. Even then, I think policing it would be a huge problem.
Kat, did you want to jump in?
Sure. So I think your question is really interesting, whether we ask too much of patent law. And on the one hand, I would say that, yes, there are many other ways in which we can try to mitigate excessive pricing through insurance and other things. But on the other hand, I would say that given the enormous economic power that's given to patent holders, I think it's not too much to ask, given that patents are meant to incentivize innovation, to ensure that that innovation is actually accessible. Because if not, what is the point? The point is not to line the pockets of pharmaceutical firms. The point is to provide healthcare technologies to the people who need it. And so in that sense, I don't think it's asking patent law too much at all.
And I'm going to take one more question over here.
Thank you. It was helpful to Fred to hear the narrative of what happened during the Article 31F waiver negotiations. Of course, at the time, one of the big debates was about whether Article 30 could be an alternative. And that part of your story I'd be interested to hear more about. Of course, later there was the MPI Declaration on Public Health, saying that the Canada panel got it wrong when it interpreted Article 30. And there are other people in the room also who remember that, and I'd just like to hear a bit more about why the waiver was chosen in the way that it was and not Article 30, and what the perception of using Article 30 in favor of access is now.
All right. I'll try to be brief. Of course, that had a long history. And when we had the first meetings on this in Norway before the negotiations really started, already, for example, MSF had proposed as their preferred solution Article 30 because of its simplicity. When I had written about it, I had laid it out as a set of options, so one or the other might work. The EU, from the get-go, preferred a Article 31 type solution. But a number of things happened. Number one, so I was working with the group of developing countries negotiating for the solution, and as I talked with the diplomats and would ask, well, how do you see the construction of the solution? For example, if you used Article 30, they would invariably say, well, of course, we're going to have a royalty mechanism, and we're going to have a notification mechanism. And it gradually struck me that the governments viewed Article 30 as still a bureaucratic mechanistic system. None of them were saying, basically, as MSF would have, we simply can do what we want, and then if someone finds out about it, then we'll deal with it. So, number one, it became clear that the negotiating governments didn't see this same thing that the NGOs were seeing. The other was, frankly speaking, at the end of the day, up until the day before kind of the developing countries agreed on where they were going, there was still an open question, but the African group basically decided and conveyed the decision. Our governments have instructed us that we're going with an Article 31-based solution. And since the African group was the party of interest in the negotiations, and we argued with them about that, but that was the decision. So that was when it became Article 31 versus Article 30. And again, I just reiterate, we all recognized on the developing country negotiating side that there were much easier ways to have a solution. The solution isn't complicated because we thought that was a good idea. It was because we were negotiating with the European Union, who had a string of things they wanted to happen before you could do that, including getting a statement from the World Health Organization that the license was needed in a particular circumstance. But that literally is the context, from my view, of how that decision was actually made and conveyed. And so that, I want to push back on
we're out of
12
time.
seconds.
Well, 12, really?
Jayashree, I don't agree that Article 31 bis requires prior negotiation because you still have the option for an emergency or government non-commercial use. So, and we made that argument to the Canadian government before they adopted their implementing legislation, but they decided to include it. So I realize that's a micro point, but I wanted to get that on the
And we need to leave the last word to Professor Reichman.
Okay, one thing, going back to the article.
We don't seem to have one that works up front.
Okay.
We'll summarize what he says.
Okay, going back.
He loves you dearly.
I want to emphasize, I think, the importance of the article that Fred and I wrote on the subject of the pool procurement strategy, the importance of that. I think it has been empirically reinforced by the new treaty on access to literary stuff for the blind, and there you see the problem. Okay, you have some blind here, some blind there, some blind there. You've got to make the market that makes it worthwhile to issue the compulsory license, and that's what pool procurement strategy does. It gives you the ability to make sure you have enough to support the cost and enough to make it put up, and that's why the regional supply center is important, because if you have the regional supply center, then all the government has to do is give the license to the regional supply center the same way that they give the license to the World Union of the Blind, which goes around and decides how it will be implemented. And that's why I think what we proposed in that article, in that respect, is more important than ever now, and I would urge people to consider it. Thank you.
So Professor Reichman was drawing a connection between the earlier idea he and Fred had put forward of pool patents and the need for a facility with the brilliance of the Marrakesh Treaty. That's an inside joke for some of you. And so with that, I think we need to wrap up the panel, and we will take just a 10-minute break, and we will have our keynote at 2:55. 2:55, 10 minutes late. And thank you, everyone.